This is appeal number 14, Herkimer County Industrial Development Agency versus the Village of Herkimer. Counsel?
Thank you. May it please the court. My name is Charles Malcolm, the appellant, Herkimer County Industrial Development Agency, and I would like to request 2 minutes for rebuttal.
You may have 2 minutes, sir.
The appellate division erred as a matter of law when it held that the IDA was contractually liable for a bankrupt company's water bills for several reasons. First, dealing with the implied contract issue, even if you were to assume that Dunbar dealt with personal liability as opposed to lien interests and the due process issues relevant to that, and even if you assuming that the existing law that the Fourth Department applied, the village regulations, can and did provide for personal liability for a non-contracting owner, the appellate division failed to apply the existing law governing the nature of the IDA's ownership issue here. Specifically, we're talking about General Municipal Law Article 18A and this court's holding in Roberts, which noted that the ownership structure is merely as a mechanism and that it functions only as a conduit and it's not true ownership. The IDA assumes no risk of loss, has no opportunity to gain, and that line of reasoning has been followed repeatedly by numerous courts. If you go back to Dunbar.
Mr. Malcolm, Judge, may I ask a question?
Yes,
Judge.
On the question of ownership, is it really necessary for the court to make it a definitive answer about this question of ownership? It seems to me that it's a much larger question than we need to resolve on this appeal. And let's say we assume that there was ownership in some form or another, and without deciding what type of ownership there is. Couldn't we resolve this question otherwise?
You know, I think it's essential that the court at least, acknowledges and interprets what type of ownership it was for a number.
Well, let me ask you this. You know, the question of ownership, as I understand it, as I understand the IDAs in New York State right now, there are 109 IDAs in New York State. It affects hundreds of projects throughout the state. The controller's report in 2019 said that there was $751 million in outstanding bonds issued by those 109 IDAs. I don't know if, without having been fully briefed on all the impact of what a decision on partial title or quasi-title or nominal title is, which is not set out in statute and has not been defined in the common law, is necessary to really dissolve a water rate dispute in a village setting. It seems to me that we could address that issue without resolving this much larger issue.
Well, I would submit, Judge Fahey, that this court already did address this issue squarely in the Roberts case. I mean, this court looked at what is the nature of this ownership. Now, the IDA, I mean, we all know that the IDA is on nominal title, and the IDA took title for a reason. And it's been pretty well established from the 1980s as to what it means when an IDA holds fee title for the purpose of facilitating financing with a particular project. And so,
if I might, I have a question for counsel.
Judge Wilson?
Isn't Roberts really about the definition of a public work under a specific statute rather than a general proposition about ownership?
The issues in that case, it was about whether an IDA project was a public work for purposes of applying the prevailing wage requirement. But in getting to the answer, this court adopted the Fourth Department's decision, which kind of explained what this title is. Like, what does it mean? What does it mean when the IDA owns title? What are the relationships between the parties? And that Roberts case has been applied many times, as you know, most recently as 2014 from the Second Department in the in the Dorval case, which
Judge, may I ask a question?
Yes, Judge Stein.
Yes, Counselor, are you saying that we cannot find in your favor without addressing this question by looking at the statute and the regs and and the interplay of the statutes at issue here?
No, because when you go to what the village law actually provides, it gives the village the ability to adopt rules and regulations, provided they're not inconsistent with law. And what the village has done here is attempted to read their regulations, which in my view are ambiguous and don't really address the issue of in personam liability versus in rem liability, and is attempting to take a contractual matter and bring a breach of contract cause of action without alleging privity, without dealing with, without even alleging an agreement of any kind between the parties. And so the reason I'm talking about the ownership issue, it's a secondary reason, but it's also what the majority opinion at the appellate division held, that there was an implied contract. And they said that based on the regulation.
Counsel, I'm sorry to interrupt you, but if I can ask you.
Judge Rivera,
Yeah,
please.
Thank you. So you agree, though, that you have title. The ADA has always had title, correct?
Since the 1980s, when they entered into this financing arrangement for in accordance
And you've not been able to,
title.
right, and you've not been able, because Quackenbush went bankrupt and you were not able to turn over the deed, so you hold the deed, correct?
That's correct.
Okay, so I understood your argument to be that although you're owners in name only, because that's how you interpret these prior cases to mean nominal ownership, that whatever ownership there is within that, right, the bundle of sticks, that nevertheless here you don't have to pay the water bill. So let me ask you this. Let's put aside the ownership for one moment. Whether or not nominal ownership would mean you are totally exempt from paying the bill at all. Let's assume for one moment we disagree and that there's some liability you may carry. I want you to address this question of personal versus imposing a lien on the property. Personal liability, what you're calling in personam versus in rem. But whether or not the only recourse for the village is to pursue the lien.
So this court essentially in the Silkman case and New York University case noted that where you have metered water rents, you're talking about, you're in the realm of contract. Now, there is an ability under the statute to impose a lien on real property, and that's set forth in Village Law 11-11-18. But that's not what we're talking about here. That's not the type of liability, the in rem liability going against the property that's at play here, because the village has chosen to seek a contractual remedy under Silkman.
No, you're correct about that completely. I'll ask him about that. But do you agree that if they wanted to pursue the lien, they could? Against the premises, you hold the title, but against the premises.
That's the pursuing the lien is one of the options that's available to the village under the statute under Village Law 11-11-18.
So you're not taking the position that merely because an IDA holds title, nominal ownership, whatever you want to call it, that they couldn't pursue the lien?
Well, against the IDA specifically, this issue was decided by the Fourth Department, and the Fourth Department determined that imposing a lien on the real property was not appropriate because the IDA held title and because it was tax exempt. So what we're talking, and that's no different than, for example, the village providing water service to out-of-district users.
Judge, sorry if weren't there two reasons? First, they didn't go after the lien because there's no value, because the property has no value. So that's why they didn't go after the lien as a practical matter, right?
Yes, Your Honor.
Okay, so as a practical matter, it seemed that way. The other reason, of course, is, and Judge Rivera referred to it, is that the lien, you have a strong exemption department because a general argument, because a general municipal law, I believe, refers to you being exempt from taxes and assessments. For both those reasons, and I thought that in the earlier iteration of this case in 2015, the Fourth Department had said that you were exempt in this context.
That's right.
Okay. All right. So it made no sense. So the only option the village seemed to have was this form of in personam jurisdiction as a result of that, and that arose in their counterclaim.
My time has expired, but if I may respond to the question.
Please do, sir.
Judge Fahey, what the village has available to it is contractual remedies under the common law, and with that party that they entered into a contract with, and that was not the IDA. It's undisputed that the village never
Right.
contracted for the
Yeah,
water.
Quackenbush was in bankruptcy though, weren't they?
They were, but because the village can't collect from the party they contracted with, the IDA, by virtue of its participation in this transaction, does not become the guarantor of bad debts.
Yeah. Thank you, Mr. Bell.
Council, from a public policy perspective, does it make any sense to hold IDAs accountable for these kinds of charges that are associated with an IDA project?
No, Your Honor. As a matter of fact, it would frustrate the purpose of the General Municipal Article 18A. The state set up this statutory regime, and I think we all know the power to tax is the power to destroy. So if you're going to impose this broad liability against IDAs that is unknown, and that if there's any risk that the company may not succeed, that the IDA is going to be a public benefit corporation, is going to be holding the bag for the bad debts of a private company, I think that would chill and frustrate the statutory purpose that the legislature set forth when they adopted the statutory scheme.
Thank you, Council. You'll have your rebuttal time. Council?
Thank you, Your Honor. Members of the court, Michael Longstreet here. Our basic position, and I know you've been kicking around this ownership issue, and I agree with Judge Fahey that it is a little bit of a case-by-case basis issue that you have to analyze. But in the Adamy case, the basic holding was that there are advantages and disadvantages to owning property for an IDA to own property. The big advantage is the tax exemption. You don't have mechanics liens hanging out there. You can't have any liens. You have to go through the notice of claim procedure. There are just a lot of protections that they have. But there are also disadvantages.
Judge Wilson?
So you rest very heavily on the Adamy case, and there's a point in your adversary's reply brief that I'd like you to address, which is that the majority there makes, the dissent there makes a distinction between 241 and 241-6. And even the dissent agrees that the rule that eventually is affirmed without an opinion by our court applies to 241, but not 241-6. So isn't it the fairest and really almost the only reading of Adamy that it states a special rule about ownership for 241 that doesn't apply to 241-6 or really any other statutory provision?
Again, I really think you have to focus on the rationale for the decision, and the rationale in our particular case for holding the IDA liable is that they're the owner for the purposes of liability. If you step back and look at what's going on here, the scheme of holding parties liable for water rents is that the owner's liable. And we have two rights statutorily.
Wouldn't UCC 1203 treat this really as a security, not as a true lease?
This doesn't. I don't believe the UCC really applies here. This is a statutory remedy granted to us under the village law, and basically, we either have the right to lien, which the Fourth Department said we don't have here, or the right to shut off water. We do not have a contract with the tenants, and in fact, water commissions throughout this state do not impose liability on the tenants because it's just impractical to manage a program in that.
Judge, can I ask a question here?
I
had thought, Mr. Longstreet, that your contract for the water rate meter was directly with Quackenbush, not with the IDA.
Actually, under our rules and regulations, and this is basically the way it works statewide, the owner's liable, and we have a right to lien.
There's one case out of Syracuse that makes that argument, but there is no statewide law on that.
Actually, Judge, if I could
let me finish my point,
sure.
and then you can respond. I don't mean to cut you off. You can respond in a second. But what I'm interested in is the village here is seeking direct personal liability against the IDA as an entity, different from a lien. And it doesn't seem that that remedy is contemplated in the village regs. The village regs, I thought, gave you two remedies. One is to cut off the water, and secondly, to impose a lien on the property. And I understand the practical reasons for not imposing a lien, but it seems that in your failure to do that, you're back to the dissent's argument in the appellate division, which is that you're conflating your in rem rights with personal liability. And personal liability is not set out in the statute. And what am I missing there?
Well, the water department rules say the property owner will be held liable for all bill.
Well,
water
yeah,
bills.
the problem there is that then we get into the situation if you can devise a remedy and whether or not that remedy is within the law. In
Well,
other words, you don't have
village-
privity. In other words, you don't have privity with them, so therefore it's not within the law.
Well, the privity argument, I think Dunbar pretty much did away with that, and they can
No, I don't
distinguish.
know about that. Dunbar was a 1917 Supreme Court case. In that case, it dealt with the right to a lien, a right for the municipality of New York to impose a lien on a property, and whether or not that imposition of a lien was a violation of your due process rights. I don't think that's a situation we have here.
But the distinction about the lien wasn't made in the Dunbar case. It was, the basis of the decision was that it was an implied contract for the reasons set forth therein. And if I could just back up a little bit to the Winston case, because
But I'm sorry to interrupt you, if I may, Chief Judge, but
Yes,
the law is it not clear that the owner can't serve as a surety? What about the surety argument?
as I said, we cannot hold the tenant liable. This is, again, going back to the Winston case, and I was not involved in that case, but
I'm
the
talking
village,
about the owner serving as a surety.
the owner is a surety of the tenant, but the tenant's not liable under the Village of Herkimer water regulations or any other regulations I know of. And if you go,
Don't you have, as Judge Fay has already pointed out, you've got your two remedies: shut off the water, which is of no consequence to you here, or impose a lien. The only problem is that, as Judge Fay has pointed out, you're not going to get any money for that, right? So that's really your problem. Did you not seek in bankruptcy to go against Quackenbush and get paid?
again, we do not have under our regulations a right to get payment from a tenant, as in the Winston case.
But you agree that you can impose a lien on the premises, correct?
We tried and we lost. The remedy we had was to take the water bill and levy it against taxes. And as soon as we did that, that was deemed to be taxes, and that remedy failed. So their position is the only remedy we have is shut off. That's it. We have no other remedy under the law against a public agency. And here again, they're taking it, they want to take advantage of it being a public entity owning the property for the purposes of the lien, but they don't want the responsibility that would be imposed individually or personally against them.
So your argument is that if someone's got to be holding the bag, it shouldn't be you. It should be them, because they're the ones who entered this agreement with Quackenbush, and Quackenbush went bankrupt.
Right, and that was their agreement. The agreement was that the tenant would be liable as though they were the owner. They knew what the liabilities were. And
Judge Wilson?
Counsel, if the IDA is correct that they are really only a nominal owner and the real owner is or was Quackenbush, wouldn't you have had a claim you could have pursued in bankruptcy?
yeah, well then, we would have to claim that they were the real owner and we had to pursue them. That's just not something that we did.
I had thought, Mr. Longstreet, that when Quackenbush went into bankruptcy, the village was listed as a creditor by Quackenbush for a tax lien for water service, about $231,000. So it seems that it was listed in bankruptcy. Am I incorrect
Well,
about
it
the
may
record?
very well have been listed in bankruptcy, but my point, and again, getting back to it, we do not have a contract with the tenants, and we don't do that for the reasons set forth in the Winston case. And I can tell you, I wasn't involved in Winston, but that was a legal services case, and they sued a lot of cities, villages, and towns throughout the state, including the village of Herkimer. We waited till that was done, and that's just the way it's done. Municipalities don't contract with tenants for the reasons set forth in the Winston case. So that's the case. I mean, I think it's pretty clear, at least to me, that we have rights under the water department's regulations to pursue them individually, and that's what we did.
Thank you, counsel. Counsel, your rebuttal?
Thank you, Your Honor. I just find it astonishing that the village is here claiming that they don't have a contract with the tenant Quackenbush here. When Quackenbush set up the meter and set up the account, Quackenbush was billed for the water all along. The village pursued as a creditor payment in bankruptcy. And during the bankruptcy, the village agreed to keep the water running during the bankruptcy. So the idea that there was no contractual relationship between the village and Quackenbush, it just actually makes no sense based on the village's own admissions in the record, the bankruptcy proceeding, and the fact that, you know, this court has held that the village does have a remedy against the user of water. These are contractual charges, and the person that comes and uses the water and turns it on and is in privity with the village has the contractual remedies. With respect to the Adame case, you know,
This again, counsel, if the chief judge will permit, I'm having difficulty seeing why, if that fails, like in this case, the person goes bankrupt, they're unsuccessful, why they can't oppose. I understand that it may not give them value here, but theoretically they can impose a lien on the premises, can they not?
well, I would normally agree with you, Judge Rivera, but the appellate division in this case, and I don't know if that's subject to a later appeal down the line, determined that because of the IDA's tax exempt status, that the lien was properly canceled by the county.
So is it your position that their only remedy would have been or may still be a shutoff?
No, absolutely not. They have a remedy to pursue under the law of the state of New York, the common law contracts, breach of contract theory with who they agreed with to sell the water to and who used the water, and they have a contractual remedy. Now, it didn't work out here.
Well, that's what I meant. In this particular case, because of the bankruptcy and all of that, their only remedy would be to shut off the water. And is that impacted by the fact that the county did that a lien was imposed through that process, but then that lien was held to be invalid? Does that in any way affect the right to the shut off?
Not the way I read Village Law 11-1118 is that they have the ability to shut it off for non-payment.
Okay, even after a lien has been imposed?
Yes, I mean, after a lien's been imposed, yes, and the lien has been extinguished in this case, so there would be no basis to say that the IDA couldn't turn off the water when there's no lien that's been imposed.
Thank you, counsel.
Thank you.
Thank you.